Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at First Appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. Before I begin with our sign-ins this morning, let me just ask if there's anyone that the jails need called out of turn.
Judge, yes, I understand on page 6, Mr. Hewitt, on page 15, Mr. Hobby.
What were those two last names?
Sure. On page 6, Diblin Hewitt.
Hewitt. Okay.
And on page 15, Cameron Hobdy.
Hobdy.
That is correct, Judge. And on page 6, the first individual,
Yes.
he requires a Spanish interpreter.
All right. So,
I've already called for one, Your Honor.
okay, so when the interpreter comes, we'll take his. Hobdy on page 15.
Please approach the judges here at Maine.
Thank
Come on
you.
up, sir.
Thank you very much. All right. Good morning, Mr. Hobdy.
Good morning.
You're before the court this morning on 2 charges. Count 1, robbery with a firearm. Count 2 is a misdemeanor capias. That has a no bond hold. I find probable cause. Before I hear from the parties, it appears pretrial is standing up, so I'll hear from them first.
Your Honor, this defendant was placed on pretrial supervision on the 5th of February in case number 20921CF10A, 1 count of a burglary on occupied structure, 1 count of resisting without violence, and 1 count of loitering and prowling. He was placed on pretrial with an electronic monitor. On the 13th of this month, we prepared a warrant for the division judge because the defendant cut off the monitor and we did not know where he was. So that warrant is, as of this point, we're waiting to see if it's gone through the system, but we did send it. So I'm not asking for anything at this point, considering count 2 and right now count 1 has no bond holds. If they haven't done that, then they will take it to him. But just to let the court know that he does have that case open.
All right, thank you for letting me know that. Okay, and now I'll go to the state.
Your Honor, the state would be seeking a finding of proof evident or presumption great for first appearance purposes only. This incident was captured on surveillance. He was identified by the surveillance video when he was apprehended. He was in the same outfit that was captured on the surveillance video. There are 2 witnesses to the incident, and clearly I think it's fairly obvious that Mr. Hobdy does pose a risk to the community. He's also has to be considered a flight risk. While he's already allowed out on pretrial, he cuts off his GPS monitor and now commits a serious act of violence.
Judge, at this time, we would object to a finding of proof evident presumption great. My recollection of the warrant on this case was that his face was obstructed. There appears to be some similar clothing involved in the incident, but there's no direct identification just beyond, I think, just his eyes or his eyebrow area. I don't believe that that amount of evidence would rise to the level to detain him without bond, and so we would object to a finding of proof evident presumption great and a holding of no bond. Thank you, Your Honor.
Thank you. That according to the probable cause affidavit, part of allegedly the defendant's face was partially covered during the alleged robbery. I believe there are actually two incidents that are included within the probable cause affidavit. Although the officer does specifically go into an extensive description of the clothing the defendant was wearing, which appears to be unique in nature according to the descriptions that are provided within the probable cause affidavit. Based on everything the probable cause affidavit taken in totality, at this time the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Habdi be held no bond on count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter. I am showing that the misdemeanor capias on count 2 has a no bond hold as well, just so that he's aware of that. He'll be having a hearing with his division judge on Monday morning in that matter.
Judge, we're just gonna be requesting a photo order.
That's fine, I'll sign that. All right, while we're waiting on our interpreter to come, I'm going to go to our sign-ins for this morning, if they are present at the jail. The first on my list is Frederick Eugene. He's on page 25. There's family present in the courtroom.
Judge, he's not here yet.
Not here
I'll
yet?
let the deputies know.
Okay, that's fine. I'm gonna place him on recall, so just let me know when he's available. All right, next will be Antonisha Knight. Her private counsel is present. Is she back for medical?
No, Your Honor, we were gonna address that issue.
Okay, all right. What's
Coffee on
going,
behalf of Ms. Knight.
okay, what's going on?
Your Honor, I spoke to Mr. Coffey yesterday afternoon about his clients. We spoke about the case, her current medical condition. If the court is inclined, and I believe, I don't want to speak for Mr. Coffey, but we both reviewed the PC this morning. I don't know that he has any probable cause objections for first appearance purposes.
I do not.
We've agreed to a bond if it's acceptable to the court, and I'd ask the court to order no contact. I believe Mr. Coffey will state on the record that he will advise his client of the no victim contact order that you've issued this morning.
Agreed.
It's a $2,500 bond, no victim contact. Once this is posted, then BSO will not have to essentially keep her in custody at the hospital.
I think all about, first, definitely I agree with everything Mr. Linder said. I will definitely let them know about the no contact. I understand actually two of the parties already was supposed to have a no contact order with
Yes,
each
they
other.
received them yesterday.
Yeah, I heard about all that fun. But I know right now she's at the hospital, handcuffed to the bed, 8 months pregnant, so.
I'm
based
aware of the
Yes, Judge.
circumstances.
So, yes, we agree to that $2,500 bond, no victim contact. And do we need a special order that, in reference to the bond being posted and she can be released right from the hospital, or?
My understanding is, well, I don't know about releasing the hospital. My understanding is, once the bond is posted, whatever deputy, whoever's at the jail on post will be notified, and they
Why
just,
don't I just confirm with confinement, since we have a situation where the defendant she's at the hospital, essentially handcuffed to the hospital bed. So once her bond is posted here, then do they need anything additional as far as to go to the hospital? Okay.
Thank you very much.
All
This
right.
was a new one even for me. I haven't had one like this.
It's a first time for everything.
Exactly.
All right, so I will make a probable cause finding per the agreement. I'll set the bond at $2,500, and I will make a note of the no victim contact order.
Judge, nice to see you again. Have a good weekend.
Same to
Thank
you, Mr. Coffey. All right, next on page 6, Arnold Molinaro. His counsel is present in the courtroom.
Yes, Your Honor. Good morning. Scott Saul on his behalf. I have an agreement to a bond with the state.
All right.
And Your Honor, if it's acceptable, well, I'll wait till he gets
Yeah,
up
let's
there.
get him up here first. All right, good
So I'll
morning, Mr.
stipulate that-
Molinaro.
Stipulate that there's probable cause in the PC affidavit.
All right.
I believe our agreement is $5,000 on one of the third-degree felonies and $1,000 for each other count.
It's 5,000 on one, yes, that's correct. 1,000 on 2 and 3, no victim contact, Your Honor.
This is Arnold Molinaro. He's on page 6. I know, everybody's very excited to get going today. All right, good morning, Mr. Molinaro. I'm assuming that you heard all of that. Your counsel is present in the courtroom with me. Per the agreement, I'm going to make a probable cause finding. I will set a $5,000 bond on count 1 and a $1,000 bond on counts 2 and 3. There will also be an order of no victim contact. Mr. Molinaro, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That no contact order also includes no phone calls or text messages to this person, and no third-party contact, no social media contact with that person. Do you understand? Okay, I can see that he's nodding his head yes, so that's fine. All right, thank you very much.
Thank you very much.
All right. Okay, and while I wait on Mr. Shate to come back on the city cases, and our interpreter has arrived, perfect timing. So now we will go to DeBlaine Hueck on page 6. And while he's coming up for my interpreter, good morning. Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. Solange Sands, Your Honor, S-A-E-N-Z.
Thank you, Ms. Sands.
You're welcome.
Good morning, Mr. Hueck.
Buenos días,
Buenos
señor
días.
Juez. Good morning.
You're before the court this morning on 3 charges.
Ha comparecido hoy, tiene 3 acusaciones.
Count 1, aggravated battery with a deadly weapon.
El cargo número 1 es agresión con agravantes con arma mortífera.
Count 2, domestic battery by strangulation.
Cargo número 2 es agresión de violencia doméstica con estrangulación.
Count 3 is kidnapping, inflicting bodily harm, or terrorizing another.
El tercer cargo es secuestrar, causar daños corporales o aterrorizar a otra persona.
I find probable cause for these charges,
Decido que existe motivo fundado para los cargos.
and at this time I will hear from the parties, beginning with the state.
Ahora vamos a
Judge,
hablar con las partes, primero con el Estado, pero hay algo de la defensa.
before we go to the bond side of the argument, I do have a probable cause argument only as to count 1.
De parte del defensor público, antes de hablar de fianza, queremos hablar de un problema con el documento de base fáctica. Solo aplica para el primer cargo.
So I don't know if the court wants to hear that now or after the state.
No estoy seguro si
I'm
quiere
ready.
escuchar el argumento en este momento o después que hable el Estado. Estamos listos.
We can address it now.
Thank you, Judge.
Adelante.
Count 1 is an aggravated battery with a deadly weapon.
El primer cargo es agresión con agravantes con arma mortífera.
I believe the facts which the state is advising supports that, or I should say law enforcement advises supports that.
Me parece que los hechos de los cuales alega el Estado apoyan a ese cargo. Bueno, de hecho, son los hechos que alega la policía.
Is on the second page of the probable cause affidavit when Mr. Hueck allegedly, quote, grabbed a vehicle key and attempted to stab Gomez, but the key did not penetrate Gomez's body.
Esto tiene que ver con la segunda página donde dice que el señor Hueck cogió las llaves de un automóvil y trató de apuñalar a Gómez con ellas, pero las llaves no lograron penetrar el cuerpo de esta persona.
I don't believe that that action caused the great bodily harm, permanent disability, or permanent disfigurement.
Me parece que ese acto no causó daños corporales graves, no desfiguró o no causó discapacidades físicas.
or that the vehicle key was a deadly weapon
o que esa llave de un vehículo califica como un arma mortífera.
for the purposes of this case and how it was used and the damage that was caused.
Y eso es con lo que tiene que ver con este caso y con el daño que causó.
So I do believe that count one should be a misdemeanor battery.
Por eso creo que el primer cargo se debe calificar como un acto de agresión de violencia, cargo de violencia de delito menor.
And I would not have an objection to finding a probable cause as to that charge.
En esa instancia, entonces no nos vamos a oponer que se decida que existe base fáctica para ese tipo de cargo.
No further argument, no objections as to counts 2 or 3.
No tenemos otro argumento y no nos vamos a oponer a la decisión tomada con el cargo 2 y 3.
All right, the state's response.
¿Qué responde el Estado?
Your Honor, it is well established that whether a weapon is to be considered deadly or not is an issue of fact for the jury.
Está bien establecido que decidir qué tipo de arma se considera un arma mortífera es una decisión que lo toma un jurado.
I think the court can make a finding of probable cause this morning based on the underlying circumstances.
Y pensamos que la Corte puede decidir que sí existe motivo fundado y esto tiene que ver con las circunstancias que corresponden con el caso
And the manner of use.
y de la manera que se utilizó.
I would certainly agree if the court should find probable cause,
Y claro que estamos de acuerdo si la Corte decide que existe motivo fundado,
that the alleged weapon being used
que la supuesta arma que se utilizó
would be a factor ultimately in whatever bond the court deems appropriate.
tendría que ser considerada para la fianza que se va a decidir para este caso.
For the purposes of today's hearing and making a probable cause finding,
Entonces, para esta audiencia que celebramos hoy y para decidir si existe motivo fundado o no,
which has a lower standard than what may be considered with respect to filing these charges as a later date,
y eso tiene una base más baja de lo que se utiliza para decidir si se van a presentar los cargos formalmente más tarde.
I'm going to stand by my finding of probable cause.
Así que decido que todavía estoy de acuerdo con la decisión previa de que sí existe base fáctica.
However, of course, I will take the circumstances into account when we discuss bond.
Y solo voy a hablar voy a decidir sobre las circunstancias relacionadas cuando hablamos de la fianza.
State's argument.
Thank you,
Adelante
Judge. That would
con
be
el
over defense
argumento,
objection.
Thank you.
aceptado de parte de la defensa.
Your Honor, as far as count 3,
Y en el cargo número 3,
the state would be seeking a finding of proof evident or presumption great.
el Estado pide que se decida que existe pruebas suficientes, presunción abundante.
And ask that Mr. Hueck be held no bond.
Y pedimos que por esa razón se decida que no se puede imponer fianza para este caso.
I would note that the allegations contained in the affidavit support the elements of the offense.
Vamos a decir que las alegaciones consideradas o listadas en el documento de base fáctica apoyan esta decisión, este argumento.
Victim provided specific details as to what occurred.
La víctima dio detalles completos sobre lo que ocurrió
The physical evidence, specifically the injuries suffered,
y las pruebas físicas, específicamente las lesiones que sostuvo,
are consistent with the victim's allegations.
están de acuerdo con lo que alega la víctima.
And there were additional witnesses on scene that corroborate the victim's version of events.
También teníamos testigos adicionales que corroboraron la versión que contó la víctima.
Should the court find proof evident or presumption great,
Si la Corte decide que existe pruebas evidente, presunción abundante,
I would ask that the court not exercise discretion in setting a bond,
pido que la Corte no decida que sí se puede imponer una fianza.
I'm very concerned for the victim's safety and well-being.
Tenemos mucha preocupación por la seguridad y el bienestar de esta víctima.
This is based on the fact that the victim sought and obtained a temporary injunction order of protection
Y esto también se basa en el hecho que la víctima había pedido y le habían procesado un interdicto por causa un interdicto para protección.
against the defendant on February 10th of this year.
Y eso se lo pidió el 10 de febrero de este año.
And, that was in Dade County.
Eso lo pidió en el condado Dade.
Now, law enforcement was unable to serve it prior to this arrest.
La policía no tuvo la oportunidad de presentar legalmente el interdicto a este señor,
But it is still relevant, as the court is aware,
pero igual se debe considerar, de eso tiene conocimiento la Corte.
that state law requires a petitioner to satisfy certain requirements,
La ley del Estado pide que la persona demandante demuestre ciertos hechos,
specifically previous allegations of violence or threats of violence,
específicamente que hubieran existido incidentes de violencia anteriores o amenazas de violencia anteriores,
in order to legally qualify to have a temporary injunction issued.
para que se pueda aceptar un interdicto temporario por causa de violencia doméstica.
Nothing further, Judge.
Nada más del Estado.
Thank you. The defense's response?
Judge,
Gracias de la defensa.
first off, we would object to the court considering the information the state just provided.
Nos vamos a oponer que el tribunal considere la información que ha hablado el Estado.
Those allegations are not contained within the probable cause affidavits presented to the court today.
Esas alegaciones no están dentro del documento de motivo fundado que se le ha presentado a la Corte hoy.
There is no crime that is being alleged as it pertains to those allegations.
No se alega cualquier delito que tiene que ver con esas alegaciones.
Further, Judge, we would object to the court finding proof evident presumption great and holding him without bond.
También nos vamos a oponer que el tribunal decida que existe pruebas evidentes, presunción abundante y que no considere que no puede tener fianza para este caso.
As we don't believe that the state has met its evidentiary burden.
Porque no pensamos que el Estado ha sobrepasado la carga de pruebas.
Which is high to constitute to support rather a finding holding him without bond.
Porque sería necesitaría pruebas mucho más altas para pedirle a la Corte que decida que no se le puede dar fianza para este caso.
All that we have before the court today
Todo lo que tenemos aquí hoy
are the unsworn hearsay statements
son declaraciones de terceros no bajo juramento
of an individual
De un
who
individuo.
apparently knows Mr. Weck.
que supuestamente conoce al señor Weck.
We have no physical evidence which has been submitted.
No tenemos pruebas físicas presentadas,
We have no photographs. We have no testimony.
no tenemos fotos, no tenemos declaraciones.
Further, there's an allegation that the witnesses support this version of events.
Además, escuchamos una alegación que los testigos supuestamente apoyan lo que ocurrió.
I think based on the single sentence that mentions the witnesses in the probable cause affidavit,
Y me parece que están utilizando solo una frase solitaria que menciona que existen testigos
does not necessarily support that reading.
y no necesariamente eso da pruebas para cuando uno está leyendo el documento.
As they allegedly confirmed the attack,
Que supuestamente estas personas confirmaron este ataque
but we're just discussing the alleged kidnapping.
y nosotros quizás ellos estaban hablando del supuesto secuestro.
There's several different spots in the probable cause affidavit,
Y hay varias partes del documento de motivo fundado
and without that testimonial evidence,
sin tener declaraciones de evidencia.
we don't know who these unnamed, not even quoted witnesses
De verdad no sabemos quién son estos supuestos testigos y qué declaraciones podrían dar.
Certainly, unsworn witnesses would testify too.
Y de hecho son personas que no habían prestado juramento y para declarar.
And so, because of that, Judge, we would object to the court finding proof evident and holding him without bond.
Por eso nos vamos a oponer que el tribunal decida que existen pruebas evidentes y que no decida que no le pueden dar fianza para este cargo.
While the allegations in the probable cause affidavit are extremely serious in nature,
Las alegaciones en este documento de motivo fundado son muy serias.
and do give the court great concern for the safety of the alleged victim in this case.
Sí le causan mucha preocupación a la Corte sobre la seguridad de esta supuesta víctima.
The information in the probable cause affidavit
La información que da el documento de motivo fundado
doesn't necessarily lead me to believe that the witnesses were to the allegations that led to the kidnapping charges.
no me hace pensar que los testigos que se nombran aquí estaban declarando sobre el supuesto secuestro.
Your Honor, if I could respond to that briefly?
Quiero responder de parte del Estado. Adelante.
Your Honor, the kidnapping didn't just occur when he first forced her into the vehicle and drove away.
El secuestro no se relaciona con cuando él por primera vez la metió dentro del auto y trató de salir con ella.
It occurred the second time also when he returned immediately
También ocurrió esa segunda vez cuando él regresó inmediatamente
and forced the victim inside his vehicle once again.
y la volvió a introducir al vehículo.
That was another instance of kidnapping,
Así que eso es una segunda instancia de secuestro
and that is exactly when the attack occurred.
y ahí es exactamente cuando ocurrió el ataque.
From my reading of the probable cause affidavit,
Al leer este documento de motivo fundado,
it appears the second instance of kidnapping occurred outside of the complex.
me parece que esta segunda alegación de secuestro ocurrió fuera del lugar donde viven, el lugar de los departamentos.
Following that second occurrence,
Y después de este segundo incidente,
the probable cause affidavit does state that Mr. Hweck managed to enter the complex
el documento de motivo fundado después dice que el señor Hueck volvió a entrar a ese lugar
and drove to the east side of the property.
y condució hacia el lado este de ese lugar.
Without more description as to the specific witness statements,
Sin tener más descripción sobre los detalles específicos que darían los testigos
or proximity of those areas,
y saber qué tal cerca estaban de esos lugares,
I'm unable to determine whether they actually witnessed those.
no puedo decidir
Alleged
si de
occurrences.
ellos hubieran sido testigos de esos incidentes alegados.
In light of the limited information that I have within the probable cause affidavit,
O sea que tengo información limitada dentro de este documento de motivo fundado,
while that does not undermine the seriousness of these allegations,
aunque no quitan algo de la seriedad de estas alegaciones,
I do not believe that it rises to the level
no me parece que es suficiente para llegar a una decisión
that would enable me to make a preliminary finding of proof evident presumption grade.
que me permite decidir que existen pruebas evidentes y presunción abundante.
So at this time, I will hear the parties' recommendations
Así que vamos a hablar en este momento sobre las recomendaciones de las dos
as
partes,
to bond and release conditions.
sobre qué tipo de fianza podríamos dar y cuáles serían las condiciones de libertad.
The state would be requesting 24 hours, Your Honor.
El Estado entonces pide unas 24 horas más.
All right, I
Muy bien.
will grant that request,
Voy a aceptar ese pedido.
give the state the opportunity to perfect and present any additional information.
Eso le da al Estado la posibilidad de arreglar y presentar información adicional.
So, Mr. Hweck, so that you understand,
Para que usted logre entender, señor Hueck,
That means that you will be reset to tomorrow morning.
Eso quiere decir que usted va a volver a comparecer mañana por la mañana,
So that the state will have the opportunity to collect and present any additional information needed.
así el Estado va a tener más tiempo para poder corregir alguna información y presentar información adicional si es necesaria.
Is there anyone else at the main jail that needs a Spanish interpreter?
¿Alguien más que necesite la ayuda del intérprete?
Yes, Judge, one gentleman, Ivan Velasquez, he's on the same page as Mr. Hewitt.
Is he the only one, Mr. Romero?
As far as I'm aware, yes, Judge.
All right, let me just get his paperwork. Good morning, Mr. Velasquez.
Buenos días, señor Velázquez.
You're before the court this morning on 2 charges.
Ha comparecido hoy por 2 acusaciones.
Count 1, domestic battery by strangulation.
El primer cargo es agresión de violencia doméstica por causa de estrangulación.
Count 2, touch or strike battery, domestic violence.
El segundo cargo es tocar o golpear con agresión de violencia doméstica.
I find probable cause,
Decido que existe motivo fundado.
and I'll hear from the parties at this time.
Ahora vamos a escuchar de las partes en este momento.
Your Honor, I'm requesting a $10,000 bond on count 1.
De parte del Estado pedimos una fianza de $10,000 para el primer cargo.
A $5,000 bond on count 2.
Segundo cargo, $5,000.
No victim contact.
Que le quede prohibido tener contacto con la víctima
Pretrial release with a GPS monitor.
y que esté bajo supervisión del Departamento de Supervisión previo a juicio y que que porte un monitor GPS.
I am concerned about the level of violence.
Nos preocupa el nivel de violencia.
I think it is reasonable to believe that the violence against the victim would not have stopped
Y me parece razonable pensar que la violencia que estaba causando en contra de esta víctima no se hubiera detenido
if there were not bystanders present that approached the defendant and intervened.
si no hubieran estado personas alrededor que se acercaron y detuvieron al acusado.
The victim suffered physical injuries to support the allegations.
La víctima sufrió lesiones corporales que apoyan las alegaciones.
And in 2018, Mr. Velasquez had a aggravated assault with a deadly weapon, battery, and culpable negligence.
También en el 2018, el señor Velázquez tuvo una acusación de agresión y de causar daños y también de negligencia.
He was convicted of those charges.
Y en ese momento se le condenó sobre esos cargos.
They were domestic in nature and against a different victim.
Tenían que ver también con violencia doméstica, pero fueron en contra de otra víctima,
Nothing further.
nada más del Estado.
Judge, unfortunately, Mr. Velasquez is not going to be able to afford the $15,000 bond the state has requested.
Señoría, desafortunadamente el señor Velázquez no va a poder pagar esa fianza de $15,000 que pide el Estado.
Financially, Mr. Velasquez is very much struggling at this moment.
Económicamente el señor Velázquez está en un momento muy difícil.
He was previously employed, he was working at Gulfstream, but he lost his job in December.
Anteriormente trabajaba en Gulfstream, pero perdió su trabajo en diciembre.
And that impacted his ability, and now he's homeless, Judge.
Y eso tuvo un impacto sobre su situación económica. En este momento no tiene dónde vivir.
So he's been homeless about 1 month, living in his vehicle.
estado sin vivienda por un mes y ha estado viviendo en su propio automóvil.
Now, from what he advised me, he's not in a financial position post his bond, but that he has a friend that he can reach out to that's a fisherman.
Él en este momento no podría tratar de pagar esta fianza, pero sí me dijo que tiene un amigo con quien puede contar. Ese señor es un pescador.
He advised me he does not know specifically his financial resources, but he believes it's not very much.
Me dejó saber que no sabe exactamente cuál tipo de recursos económicos tendría esta persona, pero no piensa que tiene mucho.
When I asked him how much he thinks using the services of bond and how much his friend can afford, he believes at most anywhere from $300 to $400.
Cuando le pregunté cuánto piensa que podría pagar esta persona, este amigo, si utilizaran el servicio de un fiancista, me dejó saber que piensa que sería unos $300 o $400.
So therefore, Judge, on count one, I'm going to be requesting a $3,000 bond, and on count two, I'm going to be requesting a $1,000 bond.
Por eso pedimos que para el primer cargo se le dé una fianza de $3,000 y al segundo $1,000.
I realize that that's less than what normally this court imposes, so we wouldn't have an objection if the court also wanted to place him on standard pretrial release.
Y sabiendo que esta fianza es menor a lo usual, no nos opondríamos si la corte decide que tiene que portar un monitor GPS.
And Judge, also we're requesting a photo order.
Y también pedimos permiso para tomarle fotos.
Tomorrow or this afternoon?
Le están avisando a la señoría que tiene un cargo adicional, es detención de inmigración. Va a tener otra audiencia de primera instancia por la tarde o mañana.
Based on the information provided,
Basada en la información obtenida,
the bond on count one will be set at $5,000.
la fianza para el primer cargo va a ser $5,000.
The bond on count two will be set at $3,000.
La fianza para el segundo cargo serían $3,000.
If Mr. Velasquez does post this monetary bond and become eligible for release,
Si el señor Velázquez logra pagar la fianza y podría quedar en libertad,
he'll be placed on a level 2 GPS monitor.
tendría que estar bajo supervisión nivel 2 y portar monitor GPS.
There will also be an order of no victim contact.
También va a tener una orden prohibiendo que tenga contacto con la víctima.
Mr. Velasquez, so that you understand the no contact order,
Señor Velázquez, para que usted logre entender la orden de prohibido contacto.
that means no being in the same place at the same time as the alleged victim.
Eso quiere decir que usted no puede estar en el mismo lugar que esté la supuesta víctima.
Since you'll be wearing a GPS monitor, that includes a 500-foot stay away from this person.
Usted va a estar portando un monitor GPS y debe alejarse a una distancia mínima de 500 pies de esta supuesta víctima.
The no contact order also means no phone calls or text messages to this person.
La orden de prohibido contacto también prohíbe que usted pueda llamar a esta persona por teléfono o enviarle mensajes por teléfono.
It also includes no third-party contact or social media contact with this person.
También prohíbe que usted utilice terceros para comunicarse con esta persona y prohíbe que usted se comunique por medios sociales.
Do you understand that, sir?
¿Entiende usted?
Sí.
Yes.
All right, I will sign the photo order that was requested.
Voy a firmar la orden para tomar fotos que pidió la defensa
And I will either see Mr. Velasquez this afternoon
Y quizás nos vemos, señor Velázquez, esta tarde
or he'll be back tomorrow morning due to the immigration hold.
o regresa mañana por la mañana para hablar sobre la detención de inmigración.
Thank you.
Gracias.
Is there anyone else at Maine who requires a Spanish interpreter?
Not at Main, Judge.
All right. Mr. Goldberg, is there anyone at any of the other jails? Okay, all right. Ms. Sands, thank you very much.
You're welcome, Your Honor. Have a great day.
Same to you. Is, Mr. Romero, is, Mr. Eugene at the facility yet?
He is, Judge. I just need one more moment to speak to him.
Okay, that's all right. I'll come back to him. Just let me know.
Thank you.
I do have another sign-in to address. I don't know if he's gonna be present, because he's toward the end of the docket, but that's Jakari McClam on page 27. Okay, let me just see if the jail has him yet.
He's, Mr. McClam? No, he's still in back, Judge. I believe our
Okay.
cutoff was 22.
All right, well,
But
you
they're
have.
gonna be bringing him, then I'll have a chance to speak to him. But he has his own private attorney?
Yeah, his attorney's here, so if they can bring him, I would appreciate it.
Page 27, McLean. They're getting him right now, Judge.
All right, thank you very much. Okay, so I'll go on to the next one until we're ready to come back to those two.
Thank you.
All right, next will be Amanda Evans.
Judge, she's here present, and she declined the services of public defender.
Okay,
Oh, one moment, Judge.
okay.
Judge, there was a misunderstanding. I believe she's already been appointed the services of public defender.
Okay, all right, good morning, Miss Evans.
Good morning.
Miss Evans, you're before the court this morning on a misdemeanor capias. This relates to a charge for battery, and this capias was issued as a result of your failure to appear at a VOP hearing. I find probable cause, in light of the circumstances, the fact that this is a capias and given the charge, I'm gonna leave the bond in place as it is, and you'll have a hearing with your division judge on Monday morning. All right, good luck to you. Mr. Shea, I'm gonna go ahead and take you since you're here. All right, I'm gonna go ahead and address our municipal ordinance cases while we wait on the other two. If I have them present, the first up will be Maureen Gale on page 2.
North Broward.
Thank you. Morning, Deputy.
Good morning, Your Honor. Gail, is that Paul Ryan?
Oh, she is?
Yes.
Okay, let me go over to Paul Ryan. Good morning, Deputy.
Good morning, ma'am.
Do you have Maureen Gale?
She's on the phone with the public defender right now, Your Honor.
Oh, okay. He's getting on the phone with her right now. Thank you.
The next,
Okay. All right. Good morning, Miss Gale. Miss Gale, you're before the court this morning on 3 charges. Count 1, false ID given to law enforcement. Counts 2 and 3 are misdemeanor capiases related to municipal ordinance violations for open container and possession of drug paraphernalia. I find probable cause. Both attorneys representing you are present in the courtroom with me. Gentlemen, what are we doing with Ms. Gale's cases?
For the 2 city cases, she's been in jail, I think, she has 3 days credit on both matters. It's time served.
Okay. Mr. Goldberg, she want to resolve the first one?
Ms. Gale, would you like to resolve that case that we just started
Yes, I
talking
would.
about? Yeah, she would,
The,
Judge.
adjudication time served on the false ID.
Okay, so it's the same problem. All right, Ms. Gale, if you would like to resolve all 3 matters today, the offer would be an adjudication, time served on all of them. Do you understand that?
Yes, I do.
And do you wish to accept that offer?
Yes, I do.
All right, I'm going to ask you a few questions before we get done. To begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Gale, do you understand everything we've discussed so far this morning?
Yes, I do.
Is anyone forcing you to resolve these cases?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorneys?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
All right, and do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I understand that.
And Ms. Gale, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. As we discussed, your sentence will be an adjudication, time served. Good luck to you, ma'am.
Okay. Thank you.
Thank you. All right, next will be Gibber Green on page 8. See it, Maine?
Mr. Gibber Green, come on up. And Judge, whenever the court's ready, I'm ready to proceed on Mr. Frederick Eugene.
All right, I'm gonna finish the MOs since Mr. Shade's here, and
No
then I'll go
problem.
to him.
No
All right, good morning, Mr. Green.
Good morning.
Mr. Green, you're before the court this morning on 3 ad charges. These are misdemeanor capiases. They're all municipal ordinance violations, and the charges are for, 2 of them are possession of drug paraphernalia, 1 of them is petty theft. I find probable cause. Your attorney, Mr. Shate, is with me in the courtroom. And Mr. Shate, what are we doing on these cases?
Judge, he is a first-degree felony in another division that's just popped up recently. I'd ask that this go to the division.
Okay, all right, so Mr. Green, I'm gonna leave the bonds in place that were set by your division judge, and you will be seeing that judge on Monday morning. Okay? Good luck to you, sir. All right, next will be Michael Pittman on page 8.
He's approaching, ma'am.
Thank you. Good morning, Mr. Pittman.
Good morning.
Mr. Pittman, you're before the court this morning on 3 misdemeanor capiases. All 3 are for open container charges. I find probable cause. Your attorney, Mr. Shate, is with me in the courtroom. Mr. Shate, what are we doing?
Judge, he is court on 224.
Yeah.
City of Nevada, it goes straight to the division.
Okay. All right, so Mr. Pittman, I'm going, since these are capiases, I'm gonna leave the bonds that were set by your division judge, and you'll see that judge on Monday morning, so you can address it then, all right? Good luck to you. Next will be Matthew Guiley on page 8.
He's approaching, ma'am.
Thanks, deputy. Good morning, Mr. Guiley.
Good morning.
Mr. Guiley, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for street soliciting. I find probable cause. Your attorney, Mr. Shate, is with me in the courtroom. Mr. Shate, what are we doing in Mr. Guiley's
Judge,
case?
he has no significant history. They've offered him time served, and to also remind him that he is quoted for the Judge John Hurley on 310.
310? Okay, all right, Mr. Guiley, 2 things, okay? Number 1, Mr. Shate is telling me you have another case in front of Judge Hurley, and he wants to remind you, you have a hearing on March 10th. So do not miss that hearing date, okay? Now, with regard to this case, if you want to resolve this one today, then your the offer would be an adjudication, time served. Do you understand that?
Yeah.
Do you want to accept that offer?
Yes.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can go ahead and put your hand down. And Mr. Guiley, do you understand everything we've discussed so far this morning?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
All right, have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, Mr. Guiley, I accept your plea and find that it's freely and voluntarily given. Your sentence in this matter will be an adjudication, time served. And don't forget about the March 10th hearing, all right?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. All right, next up will be Sean Hoffman on page 9.
Hi.
right, go.
I'd
I'd like it to be released. It's only a small citation. I haven't seen.
All right, well, don't get ahead of me here, Mr. Hoffman. Let me see. This is a municipal ordinance violation for lodging. I find probable cause. Mr. Shea, what are we doing with Mr. Hoffman's
Judge,
case?
this is the only case that he's had in power, it looks like since 1987, it's time
Okay.
served.
Time served? All right. Mr. Hoffman, if you want to resolve this matter today, the city's offers an adjudication time served. Do you understand that?
Yes.
And do you wish to accept that offer?
Yeah, all right.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. Mr. Hoffman, do you understand everything we've discussed so far today?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Okay, do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for a mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept. I'm sorry?
Okay.
Okay.
Yeah, okay.
All right, I accept your plea and find that it's freely and voluntarily given. So, Mr. Hoffman, your sentence will be an adjudication, time served. Good luck to you.
Okay.
All right, is that all I've got for you, Mr.
That's
Shea?
it, Judge, have a great weekend.
Thank you, same to you. All right, so now we're going to go to Mr. Eugene's case.
So I think ask to use a machete, like 15,000.
I'm sorry, Judge, who did you call?
That's okay, this will be Frederick Eugene.
Mr. Eugene, come on up, please. He's approaching Judge May.
Thank you. He has family present in the
Fine.
courtroom.
And the other gentleman, Judge, that you called, I believe Mr. McClam,
Yes.
is here present.
All right, he'll
Whenever
be
the court's
next
ready.
up. He'll be next. All right, good morning, Mr. Eugene.
Good morning, ma'am.
Mr. Eugene, you're before the court this morning on one charge of second-degree murder with a firearm. I find probable cause. Before I hear from the parties, to the family members who are present, are you here to observe or to speak this morning?
Speak.
Okay, so let me just say a couple things to you that I tell everyone who wants to speak at first appearances. Number one, for today's hearing, I'm not addressing any of the background or facts of the case. We're only dealing with bond and release conditions. Number two, everything that we say is being recorded and can be used against you and potentially him at a later date. You understand that? All right. So I will swear you in and then we'll go from there, okay? All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Okay. And we'll go one at a time. So for our first speaker, will you please state your name and spell your last name?
My first name is Neva. My
Okay.
last name is Telfort. It is T as in Tom, E as in Eric, L as in Larry, F as in Frank, O as in Orange, R as in Rabbit, T as in Tom. Telfort.
Ask is for you just to speak loudly into that microphone so that they can hear you over there, okay?
No problem.
All right, go ahead, Ms. Telfort.
Okay, Frederick Eugene is my baby brother.
Okay.
He is one of four of us. My brother is an honest man. My brother started his own business 7 years ago. He sells auction vehicles. My brother is a father of two, a little girl and a little boy. My brother's girlfriend is here. He is in a relationship. My brother is a homeowner. My brother is a church member, church-going man. My brother is the world. He's a child of the Most High God. He is my mother's son. His father died when he was 5 years old. My brother works very hard. My brother is here today, and we're here to support him. And my brother is not a flight risk. I am an officer of the courts. When there was an arrest warrant that was issued, we went and together as a family, we surrendered him. We love him. I just want him to know we are here. We have his back, and I'm his big sister. I love him, and I know everything's gonna be okay. I have the faith, the size of a mustard seed. God got him. I'm just here. I love him. I know Frederick's going to be okay. I know this is first appearance. I just want him to know that we have his support. We're here to support him. And I know the charge is big. So we'll be getting a private attorney for him. But right now, we just want him to know that we're here. I don't know what you could do, but he has been a member of the community. He's a high school graduate. He's done everything here. We've lived in South Florida our whole lives. We were born and raised here. We are U.S. citizens. And just want him to know that we got his back. And we love and support him.
Thank you, Ms. Telford.
You're welcome.
All right, to our other ladies who are present, do you wish to speak as well? You don't have to. She said everything? Okay. All right, so,
Judge, I just hope that you could clarify the issue of counsel with the witness while they're still here, if they've retained counsel.
well, it sounds like that you have not retained an attorney yet,
Not
correct? Okay, so not yet.
Okay, thank you, Your Honor.
Okay. All right, thank you, ladies. So now I will go to the attorneys. I'll hear their arguments, and then we'll go from there. We'll start with the state.
The state would be seeking a no bond hold upon finding a proof evident or presumption great for first appearance purposes only. Your Honor, the state is going to be relying upon the arrest warrant and affidavit prepared by Detective Zeller of the Miramar Police Department and the litany of evidence contained therein.
Mr. Goldberg?
Judge, initially, we'll just invoke Mr. Eugene's right to remain silent and free of any further questioning from law enforcement. We would object for today's hearings that the court find proof evident presumption great. I don't believe that the warrant, I think there's some issues with that warrant. I think that's going to be hashed out in litigation. I think there's some circumstantial evidence contained therein, and I don't believe that the evidence that's contained within rises to the level to detain him without bond for this serious charge. So we would object to the court's finding.
Well, I have reviewed this entire probable cause affidavit, which is very detailed in each of the points that have been made. Obviously, we can all agree this is a very serious charge. These are very serious allegations. In reviewing the probable cause affidavit, I do note that the officer has gone on to describe numerous video surveillance footage matters that have been reviewed by law enforcement, as well as, it appears, phone records and other matters of surveillance from law enforcement, all of which appear to place Mr. Eugene at the scene of the crime. I'm not going to outline in detail all of these since we're only here for the first appearance hearing this morning, but I do believe that the affidavit speaks for itself. Whether there's an issue with the affidavit that will be brought up later, that's an issue for the attorneys to decide outside of first appearances. But for this morning's purposes, the court is going to make a preliminary finding of proof evident presumption great. At this time, based on that finding, I am going to hold that Mr. Eugene be held no bond on this count. For the record, that is without prejudice for him to have the appropriate Arthur hearing before his division judge. If his family decides to retain private counsel, then of course that's something that can be dealt with by that attorney or the public defender's office before his division judge to address that matter. All right. Is there
That would be
anything
over
further?
defense objection.
Noted. Is there anything further from the parties?
No, Judge.
No, Your Honor, thank you.
All right, thank you. Good luck to you, Mr. Eugene, and to his family. All right, next will be Mr. McClam.
Mr. McClam, come on up, please.
Thank you, counsel.
There's your private attorney.
Okay. All right. Good morning, Mr. McClam. Mr. McClam, you're before the court this morning on 4 charges. Count 1, resisting an officer, obstructing with violence. Count 2, second-degree petty theft. Count 3, driving while license suspended, first offense. Count 4, attaching a registration or license plate not assigned to the vehicle. I do find probable cause for these charges, and Mr. McClam, your private counsel is present with me in the courtroom. I will hear from the parties at this time.
Your Honor, we've agreed to a bond on count
right.
1 if the court accepts it.
Okay,
Be a $2,000 bond.
all right.
Good morning, Rocco Marucci on behalf of Mr. McClam, Your Honor. Nice to see you.
Nice to see you.
That is correct. We have agreed to that bond on count 1.
Okay, all right. So in light of the agreement of the parties, I will set the bond on count 1 at $2,000. And that will be it for Mr.
Are we
McClam.
RORing them on the other 3, or what are we doing?
They don't have bonds attached to them.
Oh, no bonds attached? Okay, I'm sorry, I didn't get that.
Yeah, so it'll be
Okay.
2,000 total.
Thank you, Your
All
Honor.
right, thank you, Mr.
Have a
Marucci.
great weekend.
Yeah, you too. Good luck, Mr. McClam. All right, so going down our list, next will be Deandra Henry. What, oh, North Broward? Okay. Good morning, Ms. Henry. Ms. Henry, you're before the court this morning on 6 charges. Counts 1 through 4 are misdemeanor warrants for violation of pretrial. Those are not for magistrate. Count 5 is a misdemeanor capias related to a charge for DUI. Count 6 is a misdemeanor capias also related to a DUI charge. That has an ROR on it that's not for magistrate. I find probable cause. Do the parties wish to be heard?
No, Judge.
All right. Ms. Henry, you are going to be having a hearing in front of your division judge. I do know that was supposed to be this morning. Mr. Goldberg, do you know if that hearing's been rescheduled for her since she's here with us?
Let me look her up.
Okay.
See that it was scheduled. I think it needs to be set.
Okay. All right. So I assume, Ms. Henry, you'll probably be going in front of your division judge Monday or Tuesday of next week. So you'll find that out shortly. All right. Good luck to you, ma'am. All right. Next, I have family members signed in on Christian Campo, who's on page 9. Okay, that's fine. Just observing. Is he at Maine?
Medical reset.
Okay. All right. Thank you. So, ma'am, since he's a medical reset, that means that his hearing will be reset probably till tomorrow. Just so that you're aware of that, okay? This is Christian Campo on page 9.
Exactly.
Yeah, he has the VOP, I am.
So are we resetting him, or?
Well, he has 2 others. Can I just see that real quick?
Adam, I don't know if you're inclined to waive his appearance with the violation of probation. So there's not any, for instance, if he gets reset over the weekend, we can avoid confusion of having him brought here on Monday or when he should be in front of his judge on the VOP, which is obviously the most serious issue.
I totally understand the state's perspective here. I don't have the ability to waive him. He's going to be held no bond regardless, at least until Monday. So.
Your Honor does have the authority to find PC.
All right, the other 2 charges are, he's got the no valid driver's license and the careless driving. All right, I will make a probable cause finding in absentia on those issues. He's got the $25 bond on the 1 charge, so at least he'll be able to address the VOP hearing on Monday. So he's got Monday morning as his VOP hearing. All right, so we won't need to reset Mr. Campo. All right, next is going to be Shanovia Spencer Davis.
Judge, on the bottom of page 2, I was advised that she was transferred to Paul Ryan.
Is that Ms. Spencer Davis?
Yeah, and then I was advised that from those folks that she refused.
Okay, so we'll reset her, that's fine. Okay. Next will be Arnita King.
Judge, she's approaching and she declined to serve as the public defender.
All right, good morning, Ms. King.
Hi, good morning.
Ms. King, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yeah,
And are you declining the services of the public defender at this time?
yeah,
All right, Ms. King, you're before the court this morning on 2 charges. Count 1, possession of cocaine. Count 2, possession or use of drug paraphernalia. I find probable cause. Is the state seeking anything beyond the standard bond? All right, Ms. King, you've got a $1,000 bond on count 1. I'm gonna leave that bond in place. Good luck to you, ma'am.
okay.
Next will be Sonia Cicero.
She's approaching, Judge, here at me.
Thank you. Good morning, Ms. Cicero.
Good morning.
You're before the court this morning on 7 charges. Count 1, robbery without a firearm or weapon. Count 2, resisting an officer, obstructing without violence. Counts 3 through 7 are felony probation violations which have no bond holds. I find probable cause. I do know Ms. Cicero will have a hearing before her division judge Monday morning on the VOP matter. In light of that, I'll hear from the parties on count 1.
Your Honor, requesting a $7,500 bond on count 1, no victim contact, based on the fact that this is a allegation of violence and she's on probation for 3 separate burglaries, 2 separate grand thefts that she's already served prison time on before her probation began.
Romero, anything to add?
Judge, based on the fact that she's being held no bond on the VOPs at this time, but she did have, I think she's not working. So we're going to be requesting a $3,500 bond on count 1, Judge.
All right. Based on the circumstances, both the new allegations as well as the charges that she's out on being similar in nature, I am going to impose the $7,500 bond. There will be an order of no victim contact. Ms. Cicero, whether you know the alleged victim or not, so that you understand the no contact order, that means no being in the same place at the same time as this person. That order also includes no phone calls or text messages to that person, no third-party contact, and no social media contact with that person. Do you understand that, ma'am?
Yeah.
Thank you. Nikki Cullen. Thank you.
Hello.
Good morning, Ms. Cullen. Ms. Cullen, you're before the court this morning on 3 charges. Count 1, grand theft between $750 and $5,000. Count 2, false owner information provided for pawned items less than $300. Count 3, dealing in stolen property. I find probable cause, and I will hear from the parties at this time.
Nothing from the defense, Your Honor.
All right, anything further from the state? All right, so I will leave the standard bonds in place at this time. All right, good luck, Ms. Cullen.
Thank you.
Lillian Bentley.
Good morning, Your Honor.
Thank you. Good morning, Ms. Bentley.
Good morning, Your Honor.
Ms. Bentley, you're before the court this morning on 2 charges. Count 1, driving while license suspended, habitual. Count 2 is a speeding violation that's not for magistrate. I find probable cause, and I'll hear from the parties.
Nothing from the defense, Your Honor.
All right, anything from the state? Okay, so Ms. Bentley, I'm gonna leave the standard bond in place at this time. Good luck to you, ma'am.
Thank you.
Napoleon Culver.
He's in Conti, Your Honor.
Thank you.
Your Honor, can we skip him right quick? He had to use the restroom.
That's fine, just let me know when he's back.
Yes, ma'am.
Thank you. Robert Knight.
Conti.
He's approaching.
Thank you. This is a change of charge, is that correct? All right, good morning, Mr. Knight.
Good morning, Your Honor.
Mr. Knight, you're here this morning on a change of charge and state, I just want to confirm this is correct. The charge is being changed to domestic violence injunction, a willful violation of a domestic violence injunction, is that correct?
It is. It's essentially a lateral change of charge.
Okay, that's what I thought. All right, I find probable cause. What was the bond set at before?
Your Honor set the bond originally at $10,000 with GPS level 1. Just asked that the same bonding conditions
All
be
right.
reset.
Any objection to that from the defense?
No, Judge.
Okay.
Not at this time.
All right, so I will just place, since it's just a lateral change, I'm just gonna place the bond back. It'll be set as it was at 10,000. And if that bond is posted, it'll be pretrial with the level 1 GPS monitor. All right, okay, so Mr. Knight, essentially your bond and release conditions are staying as they are, okay? This is just a technical change.
Yes, ma'am.
Good luck to you, sir.
Thank you. Your Honor, I have Mr. Cole.
Okay, great, we'll take him. All right, good morning, Mr. Culver.
Good morning, ma'am.
Mr. Culver, you're here this morning on a change of charge. The charge was originally domestic battery by strangulation. It's been changed to battery, second or subsequent offense. I find probable cause, and, Mr. Linder, what was the bond set at?
Bond was originally set at $10,000 and no victim contact, Your Honor. He's actually being held on he's sentenced on another case. Considering that his release date is the same day, his expected release date on that charge is the same day he's being arraigned by Judge Allspector on this case, I'd ask that the court reset the $10,000 bond and no victim contact, and if there's to be any further modification, Judge Allspector can make that determination.
Judge, I spoke with Mr. Culver.
Yes.
He advised that he's unable to afford the $10,000 bond. He was going to ask the court to set the bond in the amount of $2,000. If the court was unwilling to reduce the bond to $2,000, he's asking if the court will place him on pretrial release. He's lived here in South Florida his entire life. He'll stay with his father. His father also lives in Fort Lauderdale in a residence. No objection to the no victim contact order. He is working. He does day labor. Additionally, his sister lives in the area.
Oh, he was on pretrial before and violated. Okay. All right, I will leave the bond set as it originally was, and if there needs to be a modification, then Judge Allspector can address that. So it'll just be reset at $10,000 with the no victim contact order. All right, good luck to you, Mr. Culver. Next will be Jose Lavangoli.
Judge, Mr. Lavagnoli, on page 8 requires a Portuguese interpreter.
All right.
I've already called. One will be available this afternoon.
Okay.
So if we could just reset his case for this afternoon. He's in the main jail right now.
All right, so we'll set him to the PM docket so that we'll have an interpreter present for him.
Thank you, Your Honor.
I'm gonna put a post-it so I remember that. Next is going to be Donald Streeter. All right, ladies, will you hold on to that for the afternoon docket? Thank you. Okay, he's a medical reset, Mr. Romero?
Correct, Judge.
Okay, thank you. Samuel Ojeda.
Mr. Ojeda is here present, Judge at Maine. Come on up,
Thank
Mr. Ojeda.
All right, good afternoon, Mr. Ojeda.
Good afternoon.
Mr. Ojeda, you're before the court on 2 charges. Count 1, second-degree petty theft. Count 2, resisting an officer, obstructing without violence. I find probable cause. I'll hear from the parties.
Your Honor might recall Mr. Ojeda, you ROR'd him yesterday on a motion to release for grand theft.
Yep.
He was given pretrial, I guess it's a violation of his pretrial, on a domestic violence battery as well. And it would have, within hours, it would have to be of being released. He got picked up for this offense.
Any requests from pretrial? Okay.
Judge, I'm gonna relay what Mr. Ojeda has advised me to
Well,
relate to the
Mr.
court.
Romero, just one moment. Pretrials. Thanks.
Yesterday has
Trial is requesting that his pretrial services be revoked on the case that was set on pretrial yesterday.
And Judge, the only thing I wish to say on Mr. Ojeda's behalf is he did advise me that he was out on pretrial. He was released yesterday. He says this is a whole misunderstanding. I didn't have an opportunity to review the PC affidavit, but from what he advised me, he stayed around till law enforcement came so he can explain his side of the story. So if that's indicated anywhere in the PC affidavit,
It's
at least
not.
that shows me.
It's not. So, I'm not gonna read the PC affidavit for you. We've been in these situations before. Based on pretrial's request, I'm going to grant the request and revoke pretrial services in the case that was set on pretrial yesterday.
Case number 20477 MM10.
All right. All right, I'll hear the parties' recommendations.
Nothing from the defense, Judge.
Mr. Linder? All right, the case that pretrial is being revoked in is gonna have a no bond hold on it. I'll leave the standard bond in place on this case.
It's the same Cyrus Ryan.
Next is going to be Matthew Riskissa. Thank you.
I believe been advised he's in regular court?
We mess up safe.
Is he? Can someone tell me if Matthew Riskissa is in regular court?
No,
He was.
sorry, hold on. They told me, or is he still in medical reset? One moment, Judge. Is he in medical reset still?
Yeah, regular court.
On page 11.
He is. Where's confinement's telling me?
61. 01.
Okay.
61. Judge, I've been advised he's in room number 6165.
Okay. What?
Says not in custody.
What is he? Is it a different case?
No.
I'm assuming. That's fine. All right, we'll reset him. It's Riskissa. I've already found probable cause. He was just being reset for bond. All right. Next will be Fabian Moncrief.
Mr. Moncrief is approaching, Judge, here at Maine.
Thank you.
This one case.
Good morning, Mr. Moncrief.
Morning, Judge.
Mr. Moncrief, you're before the court this morning on 4 ad charges. Count 1, burglary of an occupied dwelling, unarmed. Count 2, grand theft between $20,000 and $100,000. The 3rd ad charge is burglary of an occupied dwelling, unarmed. The 4th charge is fraud attempting to use ID of another person without consent. I find probable cause for these charges, and I'll hear from the parties.
Your Honor, these are refiled cases.
Okay?
Notwithstanding these two cases, Mr. Moncrief is being held on $58,000 in total bonds. I'm asking that the court place the original bonds and release conditions back on these charges. On each case, I'll start with 21557 CF10A. The burglary was originally set at $10,000. The grand theft was originally set at $5,000. Pretrial release GPS monitor level 2, no victim contact, no return. On 21556 CF10A, the bond on the burglary was set at $10,000. The fraud was set at $1,000. Pretrial release GPS monitor level 2, no victim contact, no return.
Mr. Romero, anything you want to tell me?
He's been in custody since 2018. My understanding, he has a public defender's office. I'm gonna contact his assigned public defender, advise him that the state, I believe they dropped him, now they've refiled these cases, so I will advise him what's going on. But as far as the monetary bond, he hasn't been working since 2018, Judge.
Okay, all right. Since his attorney's going to be addressing it anyway, I'll go ahead and set them at the bonds they were originally set at, and we'll let it be addressed at a later date. So the bond on, I'm showing it as count 41. That's a burglary. That's going to be set at $10,000. The grand theft charge will be set at $5,000. The other burglary charge will be set at $10,000. I'll leave the $1,000 standard bond on the fraud count. And I'll place the same release conditions, which are pretrial with a level 2 GPS monitor. No victim contact, no return. All right. All right, good luck to you, Mr. Moncrief. Next is going to be Sean Scott. Thank you. All right. Good afternoon, Mr. Scott, or good morning. I guess it's still morning.
Good morning, Your Honor.
Mr. Scott, you're here on 2 ad charges this morning. These are both felony capiases, and they're related to charges. Both of them are criminal use of personal identity information. I find probable cause. I do see there's a status hearing set on this for Monday morning, so do the parties wish to be heard?
No, Judge.
No, Judge.
Okay, all right, I'll leave the standard bonds in place. And Mr. Scott, you're gonna see your division judge Monday morning. Good luck, sir. Jermaine Thomas. Thank you. Good morning, Mr. Thomas.
Morning.
Mr. Thomas, you're before the court this morning on 1 ad or excuse me, is this a change of charge or an ad charge?
It is a change of charge, Your Honor.
Okay.
It's a technical change of charge.
Okay.
Originally, Your Honor found no probable cause and ROR'd him because the PC affidavit referred to the knife as a pocket knife.
Yes.
The state has filed an information, and the information refers to it as a knife. I was not able to find anything in the system giving specific details about the knife, so I'm fine with the court keeping it as an ROR. I have to believe that the case filer did receive information that it does qualify as a weapon,
Okay.
but that will be dealt with at a later date. Mr. Thomas is being held on a parole hold anyways.
Okay, all right. So I do see the charge is being changed to carrying concealed weapon. Based on those circumstances, then I'll go ahead and just leave this at an ROR as it was before. And in light of the other holds that Mr. Thomas has anyway. I do see, Mr. Thomas, you have a status hearing with your division judge on Monday morning. So you'll probably hear more about it then. Good luck to you. Brendan Applegate.
Conti?
Thank you. Good morning, Mr. Applegate.
Good morning.
Here before the court this morning on a number of ad charges. Count 7 is grand theft between $750 and $5,000. Count 8, false owner information provided for pawned items less than $300. Count 9, dealing in stolen property. Counts 10, 11, and 12 are felony probation violations which have no bond holds. 13 is grand theft between $750 and $5,000. 14 is second-degree petty theft, third or subsequent offense. 15, false owner information provided for pawned items less than $300. 16, dealing in stolen property. 17 is a felony probation violation with a no bond hold. I find probable cause for these charges. I do see, Mr. Applegate, you're set to have a hearing with your division judge on Monday morning to address the probation violation issue. In light of that, do the parties wish to be heard on the other charges?
This time, Your Honor.
Okay. All right, so I'll leave the standard bonds in place on the other charges. And Mr. Applegate, as I said, you'll have that hearing Monday morning with the division judge. Good luck to you. Daniel Arroyo. Thank you. Good morning, Mr. Arroyo.
I'm good, and you?
I'm fine. Mr. Arroyo, you're before the court this morning on 2 ad charges. Count 3 is aggravated assault with a deadly weapon without intent to kill. Count 4 is robbery with a firearm. I find probable cause for these charges, and I'll hear from the parties at this time.
Good morning, Your Honor. Elizabeth Kirkpatrick on behalf of the state. The state is requesting on count 3 a $10,000 bond hold and on count 4, a $50,000. Count 1 is a robbery firearm, Your Honor, with a no bond hold already. With the same allegations as this case, Your Honor.
Mr. Goldberg?
Judge, Mr. Arroyo is being held no bond regardless, so I think his bond status is better suited before his division judge at this time.
Okay, all right. I would agree with that. So on these two new charges, I'll set the bond on count 3 at $10,000. The bond on count 4 will be set at $50,000. There will also be an order of no victim contact. Mr. Arroyo, whether you know the alleged victims or not in this case, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victims. That no contact order also includes no phone calls or text messages and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you. Christopher Addison. Thank you. And is Mr. Addison only here on 3 and 4? We already did 1 and 2, right? Okay, I'm gonna cross those off. Should be 3. Well, it's 4's come up, 4's popped up. All right, good morning, Mr. Addison. You're before the court this morning on 2 ad charges. Count 3 is a misdemeanor capias related to a charge for driving with a suspended license. Count 4 is a felony out-of-county hold that's out of Miami-Dade County and has a no bond hold. That is not for magistrate. I find probable cause. Do the parties wish to be heard?
No, Judge.
All right, I'll leave the $500 bond in place on 3. Thank you. Wilson Thomas.
That's right, honey.
Which one?
Judge, just one request.
Oh, hold on. Yes, Mr. Romero?
Mr. Addison just wanted to know if his bond was already posted on that capias.
Let me check with confinement. It's not showing as posted right now. Excuse me. She's telling me someone tried to post the bond, but the bond was returned to the bondsman. So I'm not sure what the issue is there. Yeah. Okay. All right, I'll go on to the next case. So next is going to be Wilson Thomas. Let me go over to North Broward.
North Broward, Your Honor.
Thank you.
Good morning, Your Honor.
All right, good morning, Mr. Thomas.
Mr. Thomas, just listen to what's happening, okay?
Yes, sir.
All right, so Mr. Thomas, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied structure, unarmed. Count 2 is for dealing in stolen property. I find probable cause, and I'll hear from the attorneys.
Your Honor, I'm requesting a $10,000 bond on count 1, no return. Mr. Thomas is qualified in the state of Florida as a, just one moment, career offender. He's a habitual violent felony offender. In 2011 in Broward, he was convicted of kidnapping, strong-arm robbery, and carjacking. He was sentenced to 8 years in state prison. His most recent release from state prison was May 9th of 2019. I mean, he has a lengthy history, but obviously I would ask the court to just rely on that information. I think that really is enough for the court to take into consideration.
Okay, Mr. Goldberg.
Mr. Thomas, I'll handle it. Mr. Thomas, I'll handle the hearing. Don't worry. Judge, I've spoken with Mr. Thomas. He's asking the court to place him on pretrial release. From what he's told me, he's lived here in Fort Lauderdale for the last 19 years. Unfortunately, he has lost his job. He says that he can go stay at the Salvation Army. He spoke with them. They told him that they would take him on pretrial release. He's getting some treatment at a nearby hospital for a hip replacement, and also I understand that he broke his hand as well, and so he wants to maintain the treatment that he's going through. So he's asking if the court will place him on pretrial release so he can reside with the Salvation Army and continue his treatment at the hospital.
Your Honor, may I say one thing, please, ma'am?
You can, Mr. Thomas. I'm just going to advise you not to talk about the facts of the case at all. Don't talk
No,
about
it's
your
not about-
history
it's
or
not about
anything
the
else.
facts. Okay, all right.
All right, you understand what your attorneys just said, Mr. Thomas?
Yes, ma'am, but my previous criminal history is.
That's all right. I don't want to talk about your history right now. We'll talk about your history later.
All right, okay, Mr. Thomas, just hang tight for a minute, okay?
Yes, no, I didn't do all those.
It's all right. We're going
Alright.
to talk about the facts of the case later. Excuse me,
Mr.
Judge.
Thomas, I promise you Mr. Goldberg is very qualified to handle the hearing for you this morning, so just hang tight for a minute, please.
I never been.
It's okay. We're going to keep going.
All right, so.
Excuse me, Judge.
That's all right, okay. Well, number one, I'm not sure if there's maybe some other issues going on with Mr. Thomas that need to be addressed. In light of the fact that he was just released last year and he doesn't have a permanent residence right now, I'm a little bit concerned to put him on pretrial release. I don't want to set him up for failure to do that. What I will do is, I understand he has financial constraints, so I'm not sure how much it would help, but, on count one, I'm gonna set the bond at $5,000. I'll leave the standard bond in place. If there are some other issues that are going on, then they may be better suited to be addressed with the division judge.
Thank you, Judge.
And see if we could do it there. There will be a no return order. So, Mr. Thomas, the no return order means that you're not to return to the Riverside Hotel. You understand that? Can you just shake your head for me, yes or no? Do you understand? Okay. All right, thank you very much, sir.
Thank you, Your Honor.
Thank you. Okay, good luck to you, Mr. Thomas. All right, next will be Alpheus Marshall.
Case here, President Judge Amain approaching.
Thank you.
Good morning.
Good morning, Mr. Marshall.
Good morning.
All right, Mr. Marshall, you're before the court this morning on one charge of grand theft between $20,000 and $100,000.
Your Honor, that's an incorrect.
That is incorrect?
Yes.
What is it supposed to be?
It's third-degree grand theft.
All right.
I agree with that.
Okay. All right, so then I imagine the bond is, well, the bond was set by Judge Siegel. Okay.
Yes,
All right,
and-
I find probable cause, go ahead.
That also, Your Honor, might have been based on his history.
Yes.
He had a grand theft in 2018. He ended up, at one point in 2020, I guess, violating probation. Ultimately, he was sentenced to a year in a day state prison. It does appear in February of 2020, though, he had enough credit for time served, so that's why he was brought down here from Palm Beach on this warrant.
Okay.
I'm showing he's gone to prison for burglary of a dwelling out of Palm Beach. He's had, let's see, violation of conditional release. Sale, delivery of cocaine. Sale, delivery of cocaine. Theft. Resisting without violence. See multiple failures to appear. Trespass, more failures to appear. Grand theft, petty theft, grand theft, battery. Another theft in Palm Beach, three felony thefts in Palm Beach. Nothing further, Judge.
Okay, Mr. Romero?
Judge, as you heard, I believe this is an old case. He was extradited from Palm Beach. He was on probation. My understanding, this was a basis of the violation. He served a county sentence and his probation was terminated. He's been now in custody, I believe, for around 310 days. So obviously, since he's been incarcerated, he hasn't been working financially, he can't afford any sort of bond. Judge, when he gets out, he's gonna be residing with his brother. His brother's gonna take him in, help him out in order, until Mr. Marshall gets on his feet. And his brother resides in Palm Beach. Now, he's been living here in our community for his whole entire life. But from what Mr. Marshall advised me, he can't afford to post any sort of bond. Considering that he's been in custody for 310 days, Judge, I'm going to be asking if the court on this non-violent offense can consider releasing him under pretrial release.
Well, based on his history that was just read to me, he has a history of multiple failures to appear in violations of release conditions, so.
Well, that's obviously over 300 days ago, Judge. I'm sure, hopefully,
Well,
he's
that
been
was-
incarcerated, he's been rehabilitated. Hopefully now he's matured and makes right decisions, and that's why I'm asking the court to release him on pretrial.
I
I'll
don't
make it,
understand.
Judge.
I'm not sure how can we say that he's been rehabilitated when this is the basis for violating his probation on another grand theft.
And that's why he served, hold on, and that's why he was in custody, he served his sentence, and hopefully our criminal justice system worked, and now he's not gonna make those decisions again.
I'm not too confident in the court.
I'll make the court date, Judge.
You got assessed by the government? 3 million property?
You said he's gonna be living with his brother?
Yes, ma'am.
In Palm Beach.
Judge, I would also note, and I think it's worth noting, the way the loss prevention officer was able to identify him in this case is because he's reviewed photographs of him in that same Marshall's over the past 7 years.
I understand.
And I'm sure that has something to do with why he was received as far as probation being terminated, and he was given a sentence and he completed it. So I'm sure that played a role.
Okay. I'm not saying that Mr. Marshall has not been rehabilitated or making any judgment as to his character at all over the past year, but based on the history, I don't have anything to give me confidence today that he will be able to abide by any of the release conditions that I put on him. So those may be issues that are better suited to address with a division judge. So for today's purposes, I'm gonna leave the bond that was already set by Judge Siegel. Yes.
In that case, Judge, if the court's not inclined to release Mr. Marshall on pretrial release, at the very least, this is a grand theft, 3rd degree. I'm asking for the standard bond to be applied, considering the totality, $1,000 bond on his case, Judge.
Your Honor, Judge Siegel, you've been provided with even more additional aggravating factors than Judge Siegel even had access to at the time he set the bond. If anything, the bond he set's even more appropriate now.
All right, I'm going to leave Judge Siegel's bond in place for today. All right, good luck, Mr. Marshall. Next will be Ricardo Gonzalez Guerra.
Mr. Gonzalez, come on up.
Good morning, Mr. Gonzalez.
Good morning.
Mr. Gonzalez, you're before the court this morning on 3 charges. Count 1 is for aggravated battery with a deadly weapon. Counts 2 and 3 are misdemeanor capiases. Those are related to charges for driving with a suspended license and failure to provide proof of insurance. I find probable cause, and I'll hear from the parties.
Good morning, Your Honor. The state is requesting a $15,000 bond on count 1. It's due to, there's an order of protection that was initially sought. He's used numerous aliases in the past. He has a prior grand theft, several actually, a 2014 grand theft out of Dade, Miami-Dade, 2015 grand theft out of Palm Beach, 2 prior grand thefts. He had a previous battery, domestic battery in 2019. That was dropped.
excuse me, a pending grand theft. And, you know, he's got one pending grand theft. Excuse me, a pending grand theft in Broward right now. And just so the court's aware, the order of protection, that was sought by a different individual, not the victim in this case. Nothing further.
All right, Mr. Romero?
Judge, at this time, Mr. Gonzalez advised me he has no money. He was extradited from Palm Beach. He's been in custody for 7 months. I believe all his Palm Beach offenses have been taken care of. My understanding, I haven't reviewed the PC affidavit, my understanding is the alleged victim in this case is incarcerated here in Broward County.
Objection.
My understanding in speaking Mr. Gonzalez is that person, I believe this incident happened sometime in June of 2019, in which that individual basically perpetrated a crime against Mr. Gonzalez.
Objection.
Having said that,
This is in
Mr.
July,
Gonzalez-
just so you know. This is a
on
separate
July of
incident.
last year.
This is a separate incident.
He's 65 years old, Judge. He's been here since 1978. He lives in Lauderdale Lakes. He's been residing in the same place for 11 years now, Judge. His monthly rent is $950 a month. Right now, he's been incarcerated for 7 months, so he hasn't been working, so financially, hence he can't afford anything, Judge. And that's what he wanted me to relate to the court.
All right. I'm not gonna take any action on the pending theft case that's pending in Broward County right now. In this case, I'm going to set the bond at $9,000. There will be an order of no victim contact. Mr. Gonzalez, so that you understand that no contact order, that means no being in the same place at the same time as the alleged victim. I'm not going to comment on the victim's current status as to where he may or may not be. If they do happen to be housed in the same facility, I'm sure the jail will take the appropriate measures. Mr. Gonzalez, so that you understand that no contact order also includes no phone calls or text messages to this person, and no third-party contact or social media contact with that person. Do you understand that?
Yeah, the person in jail, right?
Do you understand what I just said to you?
Yes, I understand.
All right, thank you. I also see that Mr. Gonzalez is set to have a hearing with his division judge on Monday morning. I believe that's on the Capias matter. Thank you. Kurt Boston.
Mr. Boston, come on up, please.
Good morning, Mr. Boston. Mr. Boston, you're before the court this morning on 3 charges. Counts 1 and 2 are both felony warrants. They're relate to violations of pretrial. Those have no bond holds. Count 3 is a misdemeanor capias that's also showing as no bond. I find probable cause. So, Mr. Boston, you'll be going before your division judge likely next week to address the violation issue. I don't have a court date at this time, though. Andrew Senra.
Mr. Senra, come on up, please.
Good morning, Mr. Senra.
Good morning.
You're before the court this morning on 1 charge of second-degree petty theft, third or subsequent offense. I find probable cause, and I'll hear from the parties.
Judge, Mr. Senra, unfortunately, I'm
Go
sorry, someone talking? Mr. Senra advised me, unfortunately, he can't afford to pay a monetary bond. He just got a job working at a local restaurant as a cook, but only part-time hours, where he's making $13 an hour. He lives in Pompano Beach with his girlfriend and his 2 kids. His girlfriend right now is not working, and she cannot afford to post his monetary bond. So he's asking, at least today, under supervision.
Your Honor, the defendant has, I'm requesting a $1,500 bond in this case. The defendant has 2 pending cases. He has extensive amount of priors of petty theft from 2019.
Your Honor, he does not have any pending cases. He resolved 3 felony thefts, from what I can tell. I'm sorry, 2 felony thefts, and was released from county jail 2 weeks ago. One of those, he was court-ordered to be held no bond on, because while he was out on that felony theft, he committed a new felony theft. He's got a felony theft in 2019, another in 2018, and a grand theft in 2018. He violated probation, was sentenced to 364 days in county jail. 2016, burglary of a structure and grand theft, 18 months state prison. Felony theft, 2016, 18 months state prison. Grand theft auto, 2016, VOP, 18 months state prison. Felony theft in 2016, 2015, theft in 2014, felony theft 2014, theft 2014. The court simply can't have any confidence at this point in time that if released out of custody that Mr. Senra will not continue to commit thefts.
All right, I'm going to set the bond at $1,000. There will be a no return order to the Walmart that's at issue in this case. Mr. Senra, that means you're not to return to that Walmart location. Do you understand that, sir?
Yes.
Thank you. Robert Lane.
Mr. Lane, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Lane.
Good morning.
Mr. Lane, you're before the court this morning on 3 charges. Count 1, grand theft auto. Counts 2 and 3 are each felony probation violations, which have no bond holds. I find probable cause. Mr. Lane, I see you're going to have a hearing with the division judge on Monday morning to address the probation violation issue. In light of that, do the parties wish to be heard on count 1?
No, Judge.
All right, I'll leave that in place then. Good luck to you. Tevis Cooper.
Mr. Cooper. Approaching.
Thank you. Good morning, Mr. Cooper.
Good morning.
Mr. Cooper, you're before the court this morning on 2 charges. Count 1, operating without a valid driver's license. Count 2 is a felony probation violation with a no bond hold. I find probable cause. I do see you've got a hearing on the VOP issue Monday morning with your division judge. In light of that, do the parties wish to be heard on count 1?
No, Judge.
No, Judge.
All right, I'll leave that in place. Thank you. Ricky Green.
North Broward.
No, brother, you're on.
Thank you.
One sec, please.
Thank you.
Mr. Green. Green.
Morning, Mr. Green.
Yes. Good morning.
Mr. Green, you're before the court this morning on 6 charges. Counts 1, 2, and 3 are each a separate count for trafficking methamphetamine between 14 grams and 28 grams. Counts 4 and 5 are each a separate count for trafficking methamphetamine between 28 grams and 200 grams. Count 6, conspiring to traffic a controlled substance. I find probable cause, and I'll hear from the parties at this time.
Your Honor, the state is requesting that the bonds be kept in place. This is clearly an ongoing issue. There's been several transactions, 2 at least with over $1,000 exchanged, and as well as we're not talking about it just a little bit. It's 60 grams, one of them. The other one is approximately 60 grams as well. Another is 22, and 34 and 17. Your Honor, the minimum mandatory for count 1 through 3 is 3 years, and 4 through 5 is 7 years. Nothing further, Your Honor.
Judge, I spoke with Mr. Green. From what he told me, he's not going to be able to afford these bonds. He's lived here in South Florida his whole life. He lives in Lauderhill. For the last 5 years, he's been living with his dad. His dad is retired. Mr. Green is not working, and so he's just asking if the court will reduce this bond to a lesser amount so that way he can try to pool resources to post bond.
Was there a lesser amount that's being recommended?
I don't have a recommendation at this time, Your Honor.
Okay, all right. Based on that information, then this may be,
No, Mr. Green, I wouldn't speak at all at this stage.
based on the circumstances, if there needs to be a reduction in bond, it may be better suited to a lengthier hearing before a division judge, to determine what may be appropriate in the circumstances. Because without more information, based on what is included in the probable cause affidavit, I'm gonna leave the standard bonds in place for today's purposes. All right, good luck to you, Mr. Green.
Thank you, Your Honor.
Thank you. Cyrus Riley.
Judge, I do have a probable cause objection with Mr. Riley.
Okay. All right, good morning, Mr. Riley.
Good morning, how you doing?
I'm well. Mr. Riley, you are before the court this morning on 6 charges. Count 1, grand theft of a firearm. Count 2, carrying a concealed firearm. Count 3, resisting an officer, obstructing without violence. Count 4, tampering with or fabricating physical evidence. Count 5, providing false owner information for pawned items less than $300. And count 6 is for dealing in stolen property. Mr. Goldberg, I'll hear your argument at this time.
Thank you, Judge. I have a probable cause objection as to counts 1 and 4. Count 1 is a grand theft of a firearm. According to the probable cause affidavit, Mr. Riley is alleged to have been in possession of a firearm that was reported stolen. However, there's no allegation that Mr. Riley was the individual who had, in fact, taken or stolen the firearm. There's no allegation within the probable cause affidavit that he knew that the property was stolen. Further, there's no, I understand that recently stolen property, there could be a presumption that a person knew or should have known that the stolen property was in fact stolen. However, there's no allegation as to when this firearm was taken, and so that presumption wouldn't attach. So based on that, Judge, I would object to probable cause as to grand theft of a firearm. As to count 4, the tampering or fabricating physical evidence, the allegations are, as law enforcement is in pursuit of Mr. Riley, he took his fanny pack off and threw it. It says approximately 20 feet was the act of throwing. I don't believe that those actions would constitute tampering with or fabricating physical evidence. There's no allegation that he modified any of the objects that were found inside of this or the bag itself. Certainly everything was immediately recovered. That constitutes the basis for some of the other charges on the PC here. And so I would object to probable cause on that count as well.
Your Honor, as far as count 1, the state will concede it for first appearance purposes, finding no probable cause in ROR. We would argue that there is probable cause for tampering because under the statute, it is unlawful to conceal or attempt to conceal evidence. Clearly, this bag had evidentiary value. He threw it 20 feet while this was while he was Detective Russo was in the process of trying to catch up to Mr. Riley on foot. The fact that he was only able to throw it 20 feet is immaterial. The intent, I think, from the allegations is clear that he was attempting to conceal and prevent the detective from obtaining the evidence or being able to link it to him.
All right, based on the arguments made by counsel, I'm going to find no probable cause as to count 1, grand theft of a firearm. That will be an ROR. I am going to make a probable cause finding as to counts 2 through 6. And at this time, I will hear the parties' recommendations.
Judge, I've been talking to Mr. Riley about his bond. Before the court found no probable cause, I believe the total bond was $7,600. His family, after speaking to them, I believe late last night, the most that they come up with using the service of bonds, and if the bond was a total of about $5,000. So, Judge, I was going to be asking for a bond reduction. I was going to be asking on count 3 alone for a straight ROR, and a reduction on count 6 alone from $3,500 to about $1,000. That would have, with the bondsman, I believe the family would have been able to afford that. Now he's 18 years old, been here his whole life. He helps his dad when he can. His dad is a roofer. He's also going to school online. It's something through the Ascend school. He's obtaining his GED. Now he lives in Coral Springs with his parents. His parents are also supporting his 2 other siblings. So, Judge, I don't think he has an extensive record. So that's why the only thing we're going to be requesting at this time is a ROR on count 3 and a bond reduction on count 6 alone from $3,500 to $1,000.
Your Honor, in light of what Mr. Romero represented, I'm fine with an ROR on count 3. I'd ask for a bond reduction in count 6 to $2,000. That would total $5,000. That's essentially what he said the family can afford.
That's fine.
All right.
My math is.
All right, then count 3 will be an ROR, and count 6, excuse me, will be reduced to $2,000. All right. Good luck to you, Mr. Riley.
Okay, call your parents.
Michael Sapio,
He's approaching, Judge.
thank you. Good morning, Mr. Sapio.
Good morning, ma'am.
Mr. Sapio, you're before the court this morning on 9 charges. Count 1 is for dealing in stolen property. Count 2, false owner information provided for pawned items, $300 or more. Counts 3 through 9 are felony capiases, which have no bond holds and are not for magistrate. I find probable cause. I see that Mr. Sapio has a status hearing with his division judge on Monday morning. So in light of that, do the parties wish to be heard on 1 and 2?
No, Judge.
All right, I'll leave those bonds in place at this time. I'm sorry?
No.
Okay, thank you. Giovanni Shern,
Mr. Shern is here present in Maine. Judge, I asked him, my colleague asked him, he declined the services of public defender.
okay. Good morning, Mr. Shern.
Good morning.
Mr. Shern, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am.
And are you declining the services of the public defender at this time?
Yes, ma'am.
All right, for the record, Mr. Shern, you're before the court this morning on 1 charge of burglary of an occupied dwelling unarmed. I just want to look at something. I find probable cause for this charge, and I will hear from the state with its recommendation at this time.
Your Honor, if we could just have 1 moment, please.
Go ahead.
The state is recommending a $20,000 bond, Your Honor.
What's the basis?
Your Honor, it was occupied dwelling. He's got pending discharge of a firearm in public, openly conveying a weapon, pending in Miami-Dade, openly carrying a weapon, Your Honor. And as a minor, he has a history of petty theft and trespassing.
Your Honor, also, at least one of those thefts was a charge reduction from a burglary of an occupied dwelling.
All right, Mr. Shern, let me just say a couple things to you, okay? Since I'm only talking about bond and release conditions this morning, all right? So we're not gonna talk about the facts of your case at all. You understand that? So if you want to say something to me about bond, then I will allow you to do that. Right now, the state is requesting a $20,000 bond on this charge due to the circumstances of this arrest as well as your pending cases and prior history. You understand that?
Yes, ma'am.
All right, so is there something that you want to tell me about bond?
I would like to speak on the charge, the burglary charge.
Well, I don't want you to say anything about the facts of the case. I'm just talking about bond.
Okay.
Okay.
As far as bond, what will it be for today, for this charge?
It's for this charge that we're talking about, yes.
Oh, that'll be all.
Okay. All right.
Will I be able to bond out today? Is
Once,
what I meant to.
once a bond is set, yes. If you're able to afford it, yes.
Understood.
All right. And you understand that the state is asking for a $20,000 bond?
Yes, ma'am.
All right. Anything else?
My attorney is working on the cases that you brought up.
Yes.
And I would just like to say that as far as him working on that one, he will be able. He's working on the burglary one as well. So I don't.
Okay. So he'll be able to address it with you at a later date. That's what you're telling me?
Well, today, if I'm give him a call.
Okay. All right. You'll be able to call him after the hearing, okay? All right. So, based on that information, I'll grant the state's request. The bond will be set at $20,000. There's going to be an order of no return and no victim contact. Mr. Shern, so that you understand those two orders, that means that you're not to return to the location that's at issue in this case. And whether you know the alleged victim or not, so that you understand, that means no being in the same place at the same time as that person. That also means no phone calls or text messages to that person, and no third-party contact or social media contact with that person. Do you understand that?
Yes, ma'am.
All right. Thank you very much. Good luck to you, Mr. Shern. Reynaldo Cruz.
Judge here, man. Come on up, sir.
I'll add the A. The A is missing. All right. Good morning, Mr. Cruz.
Good morning, Honor.
Mr. Cruz, you're before the court this morning on 6 charges. Count 1, fleeing or eluding law enforcement at a high speed. Count 2, driving while license suspended, habitual. Counts 3 through 6 are felony probation violations, which have no bond holds. I see you have a hearing with your division judge on those matters on Monday morning. I find probable cause, and I'll hear from the parties on counts 1 and 2.
Your Honor, on count 1, the state is asking for a $5,000 bond. On count 2, the state is asking for $750. Your Honor, he's already on probation for fleeing and eluding. He him and another defendant had burglarized the vehicle that they were found in. They were led by police on a high-speed pursuit, doubling the speed limit, which is complete wanton and willful disregard for persons and property.
Judge, we're just requesting a photo order.
All right, I'll sign the photo order. The bond on count 1 will be set at $5,000. I'll leave the standard bond in place on count 2. And as I said, Mr. Cruz will see his division judge Monday morning. Bobby Gunn.
North Broward, I think.
He was removed? Okay. All right. Robert Bennett.
North Broward.
Thank you. Good morning, Mr. Bennett.
Good morning.
Mr. Bennett, you're before the court this morning on 4 charges. Counts 1 and 2 are each a separate charge for trafficking methamphetamine between 28 and 200 grams. Count 3, possession of heroin. Count 4, distributing or delivering alprazolam. I find probable cause, and I will hear from the parties at this time. All right.
Nothing from the state.
Okay, I will leave the standard bonds in place at this time. Good luck, Mr. Bennett.
Judge, the second two things, I don't know what the state is.
I'm sorry, sir. We're not going to talk about the facts of the case right now.
All right.
But I own my own home.
You and I spoke earlier. I know, you and I spoke earlier,
And you said nothing?
based on what we discussed.
Mr. Bennett, we're not addressing the facts of the case today. Okay, that's what your attorney's telling you, so you can talk to your attorneys about it after today's hearing, all right?
So he's my attorney.
Someone from the public defender's office is going to be assigned to your case. He's representing you today.
All right, thanks.
All right, thank you. Good luck. Samuel Bailey. All right.
Bond, Judge.
Victor Morales.
Mr. Morales, come on up. Please approach, Judge.
Thank you. Good morning, Mr. Morales.
Good morning, Your Honor.
Mr. Morales, you're before the court this morning on 11 charges. Count 1, burglary of an unoccupied structure, unarmed. Count 2, second-degree petty theft, third or subsequent offense. Count 3, false owner information provided for pawned items less than $300. Count 4, dealing in stolen property. Count 5, burglary of an unoccupied structure, unarmed. Count 6, grand theft between $750 and $5,000. Count 7, burglary of an unoccupied conveyance, unarmed. Count 8, grand theft between $750 and $5,000. Count 9, burglary of an unoccupied conveyance, unarmed. Count 10, second-degree petty theft, third or subsequent offense. Count 11, fraud, attempting to use ID of another person without consent. I find probable cause for these charges, and I will hear from the parties with their recommendations at this time.
Judge, as the bond currently sets right now, without bonds being set on 1, 5, 7, and 9, I believe his total bond is $9,000. I'm going to be requesting a $1,000 bond on counts 1, 5, 7, and 9, which would be a total of about, if my math is correct, about $13,000. Now, Mr. Morales has been here almost half of his life. He's 34 years old. He was working at a local restaurant as a dishwasher. He just lost his job. Now he's looking for employment. He lives in Tamarack with his mother. His mother is working. She works at Publix. She's the person that's going to be helping post his monetary bond. My understanding is he does have prior contact with the criminal justice system, but nothing recent. So that's why we're requesting a $1,000 bond on the third-degree felonies, Judge.
I would imagine then that Mr. Morales is keeping some information from Mr. Romero. I'm going to be requesting $15,000 bonds on each of the burglaries. I will hold off on making any other requests on release conditions until the court has an opportunity to decide what you're going to do on his pending cases. He has 3 of them. 1 for burglary of a dwelling, dealing in stolen property, grand theft from curtilage, and false ownership info in a pawn item. The second case that he has pending is 2 counts of dealing in stolen property, 1 count of grand theft, 2 counts of false ownership info in a pawn item. His third case is grand theft and felony credit card fraud. In addition to those cases, between 2012 and 2013, he was convicted of 8 attempted burglaries of conveyances, 2 counts of criminal use of personal identification information, a third case, criminal use of personal identification information and theft. He violated probation, was sentenced to just over 32 and a half months state prison. He was released from state prison in 2016. 2012, burglary of a conveyance, he violated probation. 2010, felony withholding information from a medical practitioner. He violated probation in that case. It's certainly in the court's discretion, but as far as revoking
Are all
his...
3 of the pending cases in Broward?
Yes, they are. It would appear that the court, I would argue the court really can have no confidence that Mr. Morales will not commit additional acts of burglary in Broward County if allowed to be released from custody.
What are the case numbers on those 3 cases?
The first case with the burglary dwelling is 13115 CF10A. The second case, that's the 2 counts of dealing with stolen property, 1212052 CF10A. And the third case with the credit card fraud and grand theft is 198978 CF10A.
At this time, the court is going to sua sponte revoke Mr. Morales' bond in the 3 pending cases. I'm going to repeat those case numbers again for the record. Those are cases 1913115 CF10A, 1912052 CF10A, 198978 CF10A. I'm going to hold that he be held no bond in each of those cases so that he can further address those matters with his division judge. Furthermore, in the case that's before the court this morning, on counts 1, 5, 7, and 9, I'm going to set bond on those counts at $10,000 each. There will also be orders of no return and no victim contact. Mr. Morales, whether you know the alleged victims that are involved with regard to the new charges or not, that means you are not to have any contact with them, no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media contact. The no return order also means that you are not to return to any of the locations that are at issue in this case. Do you understand that?
Yes, ma'am.
Thank you. It's never helpful when you lie to your attorney. Christopher Davis.
Come on up, Mr. Davis.
Good morning, Your Honor.
Good morning, Mr. Davis. Mr. Davis, you're before the court this morning on 6 charges. Count 1, battery on an officer, firefighter, or EMT. Count 2, resisting or obstructing an officer with violence. Count 3, resisting an officer obstructing without violence. Counts 4 and 5 are each a separate count for resisting an officer obstructing without violence. Count 6 is for tampering with or fabricating physical evidence. I find probable cause for those charges, and I will hear from the parties at this time. State, do you have recommendations on 1 and 2?
Yes, Your Honor, just one more. 5,500 to give us some pending.
Your Honor, on count 1, $5,000 bond hold, and count 2 was a 500 count bond hold. Your Honor, he has a pending firearm by felon.
Judge, we can't hear you.
I'll repeat it. Let me just go. They're requesting 5,000 on 1, 500 on 2. They're telling me he has a pending, what is the pending case?
Firearm by felon, a carry concealed firearm, and a resisting without violence, Your Honor. He's got priors, including a battery on a individual over the age of 65 years old, a previous resisting without violence, firearm by felon, possession of PVP, and possession of methamphetamine.
That pending case is pending in Broward?
Yes, Your Honor.
All right. Mr. Romero?
Judge, Mr. Davis was completely honest with me. He told me that case that he was out on, he has a public defender's office. My understanding is he went to court, he scheduled a court, or go back to court. I believe it's in front of Judge Lynch. Based on the totality of the circumstances, at this time, what the state is requesting on bond amount is reasonable.
All right, I will not take any action on the pending case. I will set the bond on count 1 at $5,000. The bond on count 2 will be $500, and I'll leave the standard bonds in place on the remaining counts. Good luck to you, Mr. Davis. Kevin Shaw.
Mr. Shaw, come on up, please.
Good morning, Mr. Shaw.
Good morning, Your Honor.
Mr. Shaw, you're before the court this morning on 4 charges. Count 1, carrying a concealed firearm. Count 2, use or display of a firearm during a felony. Count 3, possession of cannabis greater than 20 grams. Count 4, possession with intent to sell, manufacture, or deliver cannabis. I find probable cause, and I'll hear from the parties.
Your Honor, the state is recommending a $1,000 bond on count 2.
All right. Mr. Romero?
Judge, that's reasonable as far as count 2. Our only, if the state can confirm, my understanding is that he has a clean record. On count 3 alone, if the court would consider an ROR simply on that one count.
Any objection from the state? All right, so the bond on count 2 will be set at $1,000. Count 3 will be an ROR. Good luck, Mr. Shaw. Thank you. Edward McLeod. Okay. Steve Miklos. Is he still out?
Judge, I'm advised he's medical reset.
Well, if we could clarify, Your Honor, because the issue yesterday was he refused. And I'd really like to know if he refused again or if it's a medical reset. Well,
Which facility was he at?
North Broward Room.
Okay, we'll just ask one for Howard. All right, Deputy, can you tell me on Steve Miklos, is he a medical reset or did he refuse?
Yes, I called the unit and they said he's a medical reset.
He's a medical reset, okay. All right, he'll be reset. Thank you. Pablo Gomez.
Judge, I'm advised he's a medical reset as well.
Yeah.
Okay. Did I already make a PC finding on his?
I don't know if you, I mean, I imagine you would have it on your findings if you did.
Yeah, I don't have it yet.
I'd ask the court to make a PC. I think you said you were going to give it one more day.
Yeah, I think that's what I said yesterday. Because he's been reset a couple times. All right. On Mr. Gomez's case, I'm going to make a probable cause finding in absentia, and we'll have him reset for bond. James Miles.
He's still on.
He's still gone?
Yes, he's on. Yes.
Okay. All right, he'll be reset. All right, that brings us to the end of our morning docket, so I'll see everyone back here at 1 o'clock. Did you have one more?
No, well,
You have a problem? Yes? You have a
I
problem?
didn't have the file at the time of magistrate, and so we wasn't sure if he was here on our county with the case. He was here on all 4. What happened, he was never magistrated, he was ad counter
Right.
at the same time. So it was 1 through 4, and we scratched out 1 and 2.
Well, I'm showing he's also been ad charged on count 5. I mean, he's been ad charged in addition.
So he'll be coming
But
back
not
anyway?
on those, no. They booked him on 1 and 2.
Yep.
And then before he could even be seen, another hit came through.
So then
So
today I
that's
only
not-
got the stuff for 3 and 4.
And the reason I bring it up, Your Honor, what I'm suggesting, unless Mr. Goldberg has an objection, since he has a no bond hold out of county, it just has to have everything reset for tomorrow morning, so we don't come back this afternoon on 1 and 2, and we don't have 5, and then he's got to.
Right, you said he has an ad charge at number 5 anyway, right?
I just checked BSO Pix, and now it's showing a count 5, use of false ID adversely affecting him.
You didn't have paperwork for
No,
1 and 2?
I didn't. So would you just have them set all of that
Reset.
on
We can
tomorrow
reset
morning?
1 and 2 then.
Yeah, they can be set on tomorrow morning's docket. He'll have that ad charge anyway.
Your Honor, is it okay if I, considering we just dealt with it so late,
Yes.
can I provide you with the orders on Mr. Morales this afternoon?
That's fine.
Okay,
That's
thank you.
fine. All right, I'll see everyone back here at 1.